Welcome to the Importance of Confidentiality, a safe place training presented by Paley Belt. Learning objectives for this training include to identify how agencies such as Safe Place that receive funding from the Violence Against Women's Act, VAWA, or the Family Violence Prevention and Services, FIFSA program, protect confidentiality and the privacy of persons to whom those grantees and subgrantees are providing services for, as well as what to do in certain situations where confidentiality may be compromised, what it means to be a mandated reporter, and what the exceptions are to confidentiality. So what is confidentiality? Confidentiality means that information shared within a relationship will not be shared outside that relationship. Reasons survivors find confiding difficult has to do with trust. They may not just trust you yet. Fear of disclosure, whether it gets revealed in court to the police, other advocates, other clients, etc. This then can lead to their abuser finding out where they are and compromising their safety. It also may be a matter of life and death. Many survivors have been threatened with additional harm if they reveal what has been done to them by their assailants. So why do we protect confidentiality? Maintaining confidentiality is essential to preserving the safety, privacy, and trust of those seeking services. This personal risk that individuals are taking is put in jeopardy if confidentiality is compromised. If an abuser were to discover that a victim is receiving or seeking services, that abuse could worsen. There could also be societal and personal repercussions from being identified as a victim or survivor, such as housing or job discriminations. And as an agency that is grant funded by VAWA and FIFSA, we can also lose our funding if we disclose protected victim information. So even if a service agency, concerned family member, or caller is asking to leave a message, we want to first protect our client's safety and trust of confidentiality by responding with, I can neither confirm nor deny, which is Safe Place's official policy statement to protect confidentiality. However, you may take a message and notify your client and offer to fill out a release of information form if it is wanted or requested by that client for further communication to be approved and accepted. This is critical to continue to make that choice and protect our clients' confidentiality. Going into laws protecting confidentiality, so we discussed these earlier, VAWA and FIFSA, the Violence Against Women's Act, and the Family Violence Protection and Services Act. So both contain strong confidentiality provisions that limit the sharing of victims' personally identifying information. These provisions protect the safety and privacy of victims of domestic violence, dating violence, sexual assault, and stalking.
What is VAWA? The Violence Against Women Act, or VAWA, is a law that was enacted in 2013 that protects tenants from being denied assistance or terminated from federally assisted housing on the basis of or as a direct result of being victims of domestic violence, dating violence, sexual assault, and stalking. The applicant or tenant must otherwise qualify for admission, assistance, participation, or occupancy. Housing providers covered by VAWA. VAWA covers the following housing providers: public housing, Section 8 housing choice vouchers, Section 8 project-based housing, Section 202 housing for elderly, Section 811 housing for the disabled, Section 236 multifamily rental housing, Section 221, subsection D, subsection 3, below market interest rate, or BMIR, housing opportunities for people with AIDS, or HOPWA, Continuum of Care and Emergency Solutions Grants Programs, Housing Trust Fund, Rural Development Multifamily Housing, And finally, low-income housing tax credit, or LITC. VAWA does not cover private housing providers that do not receive federal assistance. However, there may be local ordinances that provide protection. If you are the victim of domestic violence, dating violence, sexual violence, or stalking, and your housing provider receives federal funds, you have the following rights. You cannot be denied admission to a federally funded housing provider. You cannot be denied federal rental assistance. You cannot lose your federal rental assistance or subsidy. And finally, you cannot be evicted simply because you have been threatened or are the victim of domestic violence or stalking. Caution: VAWA cannot always prevent eviction. There are circumstances where you can fall under the act and be evicted. If you are served with an eviction notice, you should contact your local legal aid immediately. Your housing provider or landlord is required to tell you about VAWA's housing protections when you receive assistance, upon move-in, at recertification, if you are denied admission or assistance, if your assistance is terminated, or you receive an eviction notice. This form is Form HUD-5380. Your housing authority or landlord must keep your information confidential unless disclosure is required to evict the abuser, disclosure is required by law, or disclosure is with your permission. Frequently asked questions. Do I have to ask for VAWA protection? Yes. While your request may be verbal, it is always best to do so in writing. You may submit a signed letter, or you may use the form given to you by your housing provider. What if I live with my abuser? If someone you live with has used violence against you, your housing provider may evict your abuser alone. A change in family size, however, may require you to move into a unit of appropriate size. What if I am not head of household or it is not my subsidy? You should generally have 90 days, that's 90, or until the end of the lease to establish eligibility for the housing or subsidy. You may also request an emergency transfer if you believe you are in danger of more abuse or you have been the victim of sexual assault within 90 days of the request. Your housing provider must have an emergency transfer plan. Do I have to prove that I am eligible for VAWA protection? Your housing provider may request documentation that you are a victim of domestic violence, dating violence, sexual assault, and or stalking. The request for documentation from your housing provider must be in writing. You can submit one of the following: a form developed by the Department of Housing and Urban Development. It is Form HUD-5382. Or you may provide a letter from a third party who is providing assistance with the situation. Or you may provide a police report or court order or other record that reflects the incident. Your housing provider may not request more than one of these three options. And once that information is provided, the housing provider can only request additional information if the abuser claims to be the victim. A Along with VAWA, the Federal Fair Housing Act offers additional protections based on a person's sex or gender. These protections are extended to any housing provider that falls under the Federal Fair Housing Act. Sexual harassment. Sexual harassment is a form of sex discrimination prohibited by the Fair Housing Act. Sexual harassment comes in many forms, and it disproportionately affects women. However, it is not limited to women. The Act lists 2 categories of sexual harassment. Those categories include, but are in no way limited to: 1. Requiring a person to submit to an unwelcome request to engage in sexual conduct as a condition of obtaining or maintaining housing or housing-related services. And 2, subjecting a person to severe and pervasive unwelcome sexual conduct that interferes with the sale, rental, availability, or terms and conditions and privileges of housing or housing-related services, including financing. Reasonable accommodations. VAWA protections are limited to tenants. However, under the Fair Housing Act, you can make a request of your housing provider to make an exception to their rules, regulations, and requirements. This request, known as a reasonable accommodation, allows the tenant to request VAWA protections if a live-in aide is a victim and may request an emergency transfer for the household. Familial status. A housing provider may not discriminate against tenants or prospective tenants based on a family member's sex, pregnancy, or minor children in the household. A housing provider cannot refuse to rent to families with children, except registered senior housing, require families with children to occupy a certain floor, enact rules that are aimed at children, with minor exceptions for health and safety. Additional considerations. Establish a safety plan. Obtain an order of protection and give a copy to your local police department. Once obtained, inform neighbors and landlords that the abuser is no longer allowed to be in your home. This may be a difficult step, but it is necessary to protect yourself and your family. Keep IDs, birth certificates, and other important documents in a safe place. For additional support, please contact the National Domestic Violence Hotline at 1-800-799-7233.
The Family Violence Prevention Services Program, or the FIPSA program as we call it, provides a dedicated funding stream for domestic violence shelter programs and support services around the country, as well as supporting the efforts of states and national programs to coordinate those services and provide technical assistance. It actually reaches over 1,600 domestic violence programs around the country, state domestic violence coalitions, over 200 Native American tribes, and a national network of resource centers, institutes, and a national domestic violence hotline. Over time, I think the biggest change in the FIPSA program has been the growth from a tiny demonstration program in 1984 to now a national federal funding stream for domestic violence services that reach 1,600 programs around the country or more. What's remained stable is its core purpose, that it's dedicated to domestic violence shelter and support services and the coordination of those services in the states. And we've always maintained a real priority around serving underserved populations around the country and in making sure that children who are exposed to domestic violence get the services that they need. To me, what's exciting about the FIPSA program is that it's very much driven by the needs and the trends in the field. We're constantly responding to some of the issues, some of the needs that are coming to programs around the country, and to the great innovations that state domestic violence coalitions and resource centers and institutes come up with to respond to special needs of people who deal with domestic violence from different communities with different issues. And it's a constantly evolving program that, along with the domestic violence field, evolves to get better and better. Personally, I'm very excited to be part of the FIPSA program. I started my work in this field in 1983 and love this work. It's been very rewarding to work with the incredible people who do this work around the country. And I think the FIPSA program is really at the heart of domestic violence services around this country. It plays a critical role. And our goal is to make sure that the resources that we have get out there to the field for those critical services, and we know that programs rely on us to do that. I think it's important for state administrators to know that FIPSA is part of a tapestry of funding that goes to domestic violence programs, combined with some of the resources from the Department of Justice, the Office for Victims of Crime, the Office on Violence Against Women. It fills in some of those blanks and focuses on those core domestic violence services, shelter and support services, that many other federal funding streams don't target. Programs need all of these resources put together in order to meet the needs of survivors who come to them, and that programs still struggle to have enough resources to meet the needs and the people who come to their door. We hope that state administrators will be part of the problem-solving team at the state to try to pull together the combined federal resources, private resources, and state resources to help programs meet those needs.
I would like state administrators to view FIPSA as available for TA, for assistance whenever needed. I think the biggest misunderstanding about FIPSA or grant management is that we're punitive. I think that most of the work that we do in conjunction with state administrators, with coalitions, with our communities. And I think we do it as a team. The FIPSA program is always available and ready to assist, that we see ourselves as a part of their state community team.
We rely on several things from the FIPSA office and staff. It's technical assistance for one, funding, two, and we also rely on them for, sometimes we have to bounce things off of them to make sure that we're going in the right direction.
I would like the state administrators to view our program as open and available at all times. I would like them to view the FIPSA program as a program that's user-friendly, a program that's there to provide assistance directly to state administrators and the community as need be.
Our hope is that state administrators see the FIPSA office as a resource to them, someone they can work with to make sure that FIPSA funds reach the programs in the field that need it. We share responsibility in that job. We're all stewards of these federal funds. We do it at the federal level, they do it at the state level, and we hope that they stay in close touch with us, that they let us know when they need more information, and that we work together as a team to support the programs in the field.
How do these regulations protect victim information? So VAWA and FIPSA prohibit sharing personally identifying information about victims without written, informed, and time-limited consent. Also, no program can share personally identifying information in compliance with federal, tribal, or state reporting, evaluation, or data collection requirements. HMIS is the Homeless Management Information System. VAWA amended the McKinney-Vento Homeless Assistance Program. This protects victims' personally identifying information by preventing local victims service programs from putting personally identifying information into HMIS, even if it was encoded or scrambled. Victims services providers must provide information that is non-identifying to HUD. Release of information. So a client may request that their personal confidential information be shared by a victim services provider for a specific purpose through a time-limited or 30-day period. This can look like an emergency contact, designated emergency contact for children while in shelter, with housing agencies, or if a client was wanting someone to call or speak to them while in shelter or have an advocate call on behalf of them. So whether a client is in shelter or through non-residential services are being provided, a client's confidentiality may only be released upon a client request or our ethical obligations as mandated reporters. Mandated to report. So Safe Places policy is that when an employee or volunteer intern obtains information that suggests abuse or neglect of a child or vulnerable adult has occurred, both the employee and their supervisor will act quickly and appropriately to report to centralized intake and respond to those concerns. We make every attempt to inform and involve the client of the report and to involve the client in the report process unless there is reason for safety concern, i.e. like fleeing or escalation of the situation. So we are considered mandated reporters and will act in compliance with the Michigan Mandated Reporters Resource Guide and all applicable laws. This includes legal obligation to file verbal report immediately and written report within 72 hours to MVHHS centralized intake. There is now an online intake form option available. You take any concerns to your supervisor, and anytime there may be a violation of confidentiality, supervisor or on-call staff must be called. All right, a shelter scenario for confidentiality. So Adult Protective Services comes to the door at Safe Place looking for a client that is staying in shelter. The APS worker says that you are impeding with their investigation if you do not let them in. What do you do? Scenario discussion. So, unless a client is a threat to themselves or is wanting to work with APS and has a release of information signed, we cannot confirm nor deny that that client is staying with us or is and or has participated in services. And note, if we were the ones that called APS or the police or CPS, we would let them into shelter to continue with the situation investigation. Confidentiality scenario number 2. All right, so you see a client at the grocery store. The client looks at you and clearly recognizes you as you guys are in the same aisle. What do you do? So in this situation, you would do nothing at all. Reasons would be you do not know who the person might be with at that time. So for ethical and safety boundaries, you act as if you are strangers in public and you follow their lead. Because if they are with someone that may be or know their abuser, any interaction could put them in danger or at risk for more danger, as well as putting yourself in potential danger or risk. So confidentiality within the agency. When the client makes the choice to disclose information to you as staff or volunteers, they are trusting you with that information. Some information, such as on agency forms or in our database that we use, EmpowerDB, this is accessible to all staff and interns. But what about the information we gain through conversation and interactions? If the client discloses personal information to advocates or volunteers or interns, are there times when that information should be kept to yourself? Potential examples would be a client venting about personal issues, or conversations heard or told to you through walkthroughs or client interactions. Are there times when that information should be discussed among other staff? Examples could include a client venting about communal living issues with another client or staff member issues, a client expressing mental illness struggles or substance abuse struggles. Also could look like conversations heard through walkthroughs about child abuse or self-harm. Another example would be a client expressing a need for a resource with an outside agency. All right, confidentiality within law enforcement and the court system. So working with a prosecutor, all motions to gain access to client files will be opposed. And our legal advocates do an amazing job about explaining confidentiality within law enforcement and the court system. So working with law enforcement, when law enforcement comes to the door looking for a client, regardless of the reason, we always say our policy line: we cannot confirm nor deny. At that point, if the person is a client and is at shelter, we can let them know there is an officer looking for them. We can also assist that client with options going forward, but never advising a client, giving opportunities and options available. So when providing testimony, if a client requests counselors or advocates to provide testimony, within confidentiality, typically we do not advise this, as this may jeopardize the confidentiality of the counselor-client relationship, including making the entire client file admissible in court. We are not expert witnesses, and normally we tend to suggest being a supportive presence for them, aligning with our empowerment philosophy. Confidentiality and technology. So if a client is not able to talk on the phone and is not in person with an advocate, there are other options available. However, safety planning with a client is something to consider to ensure that their safety and privacy while using these other options is maintained. Other options like text and email are great tools to use with an advocate, but that potential for their abuser to see the chat, call, email history is possible. So to maintain confidentiality and decrease risk, we want to make sure that when using an alternative option, that client has noted and communicated that these options are safe to use with an advocate. When leaving a voicemail for a client, we want to leave it vague. An example could sound like, "Hi, this is Callie. I'm returning your call from this morning. You were asking about some information. You may call me back from 8 to 5, Monday through Friday. I'm at extension 24. And within shelter, we do have a confidentiality rule that no photos or videos or calls can be taken within shelter. Unique situations and how to handle them in regards to confidentiality. A duty to warn. So as mandated reporters, we do have a duty to warn. And in this situation, if a client says to you that they want to go to their attorney's house and harm them, what would you do? How would you handle this? So if a client does mention that they have a plan to go physically harm their attorney, as advocates, we do have the responsibility to warn that individual. In this situation, you would contact the on-call staff member who would help guide you in the steps to report and handle that situation. And depending on that situation and individual, we do have a responsibility to our client to de-escalate and intervene and help with what our client is experiencing, if appropriate and applicable. A duty to warn. If a client discloses that they would like to go to their abuser's house, how would we handle this? If a client mentions that they are going out to go interact or hang out with their abuser, we encourage our client. We can offer the option or encourage our client to focus on their goals and empower them to move forward towards their future. We can also offer referrals to our counselors, legal advocates, survivor advocates for further assistance and empowerment if that seems like an appropriate advice or option to give. But we are not experts in our client situations, so they would know the correct action to take, whether that's referrals with Safe Place Services or going to interact with their abuser at that point in time. Situations about harm to oneself. So if a client is under the influence, how would you handle this situation? If a client is in shelter and under the influence and healthcare or police assistance is required, we do have emergency procedures that you can follow to go through the process, whether that be for EMT, ambulance, police, fire department. Also contact your supervisor and on-call staff member for support, guidance, and help throughout that situation and crisis. Unique situation, if they are a threat to others. So Safe Place is a safe area family environment, and it is our commitment to our clients providing a peaceful communal shelter environment. So we do not tolerate any forms of danger or violence, and if there is an incident between clients, we are mandated to report to the appropriate authorities as well as de-escalate the discrepancy between clients. These are all situations that require our knowledge of ethical boundaries and our duty to report. In any crisis situation, reach out to your supervisor or the on-call staff member immediately. You never have to handle a crisis situation alone. You are not alone in this. All right, the final part of our confidentiality training includes our MyVan confidentiality video. So this goes through understanding the confidentiality requirements of VOCA, FIPSA, and VAWA. So the next couple of slides will be the MyVan confidentiality.
Welcome to the webinar series on understanding the confidentiality requirements of VOCA, FIPSA, and VAWA. This series has been prepared by the Division of Victim Services within the Michigan Department of Health and Human Services. It's also been prepared with the assistance of the Michigan Victim Advocacy Network. The series consists of several short modules designed to help you learn the basics of confidentiality, as created by these federal laws and regulations.
Understanding the confidentiality requirements of VOCA, FIPSA, and VAWA. This is Module 1 on confidentiality and privacy. This module covers why privacy and confidentiality are important in the work that you do as a VOCA, FIPSA, and VAWA-funded victim service staff. It's also going to cover why privacy and confidentiality is so important to the people that you serve and what privacy, confidentiality, and privilege means. In the greater webinar series, you're going to learn all about the federal funding requirements of confidentiality for the people that you serve. Future modules will cover VOCA, VAWA, and FIPSA statutes and regulations on confidentiality of victim information, the difference between community-based advocates and systems-based advocates, including what that difference means with respect to your obligation to maintain confidentiality. It will examine the concepts of personally identifying information and individual information that is protected from disclosure under VOCA, VAWA, and FIPSA. We'll cover releases of information to permit disclosure of otherwise confidential information, and we're also going to share with you when disclosure is mandated by statute or by lawful court order and what you do in those cases. So I want to talk about a scenario and have you think about one that's not an unusual scenario. Jaden is a 17-year-old community college student from Lapeer, Michigan, who attended a small party at Kevin's campus apartment in Ann Arbor on Friday night. Kevin is the boyfriend of Jaden's older sister, Tara. Tara and Kevin have a child together that Kevin helps support. Jaden drank too much at the party, started to feel like she was going to vomit, and went to lay down in Kevin's room to sleep. She came to consciousness with her pants pulled down to her ankles and Kevin straddling her, penetrating her with his penis. With some effort, Jaden was able to push him off and away from her. Jaden left Kevin's room crying and upset after the assault. Some of Kevin's friends saw her leave and laughed. Jaden drove home on Saturday. She calls your program on Tuesday morning, stating that she was sexually assaulted. So take a minute just to quickly read through this scenario to yourself before we move on. All right. I want you to think about and ask yourself, what are things that Jaden may be worried about? Quickly jot down 3 answers that come to mind for you. We're going to pause here for about 20 seconds so that you can do that. So write some down. So I'm going to start sharing with you some of the things that Jaden may be worried about. You may have thought of these and several others that Jaden could have. Am I injured? Did he give me a sexually transmitted disease? Oh my gosh, my sister. What if my sister finds out? Will she believe me or believe him? And if she believes me, what happens to Kevin's relationship to my sister's baby? And if she doesn't believe me, what does that do to our relationship? I was drinking and I shouldn't have been. Will I get in trouble? I don't want my parents to be disappointed in me. Am I pregnant? What do I do if I am? So these are some of the concerns. There may be others that Jaden may be worried about. I want you to consider whether Jaden would tell you all or only some of what was done to her if she believed that you would inform others, or if she believed that what she told you could possibly get back to Kevin, to her sister, to her parents, or to the police without her consent or knowledge. Control of information is critical to victim decision-making and healing. Jaden may not want anyone else to know right now until she's been able to sort through her concerns. She's experienced trauma, and expecting her to be able to make informed decisions immediately is asking a lot from her. As her advocate or support person, one of the things you may be able to do is help her sort through this, to help her understand the options and explore the possible consequences for sharing her experience. So confidentiality allows victims like Jaden to make informed decisions about what to disclose and to whom. To be fully informed about their options, about possible consequences in their lives based on the options they choose. For example, you can help her identify the decisions she may need to make first coming to you, and one of those could be whether or not to have a sexual assault medical forensic exam. Confidentiality also allows victims to seek help at their own pace and from the people they choose to seek help from. They can safely tell their stories to those they trust. They can find protection, and they can establish and or maintain community supports. Being able to safely tell one lived experience can enable the justice system, healthcare providers, and others in the community to respond appropriately to her victimization. And finally, control of this information can prevent survivors from losing their jobs, community status, family relationships, friendships, and other connections. And all of that will help these victims and survivors heal. Control of information is also critical to the safety of the victims that we're working with. Perpetrators, especially those engaged in intimate partner violence, can use information disclosed by the victim or survivor to do several things. To locate them. For example, in an intimate partner violence situation, an abuser may make a missing persons report to law enforcement, and it's being used as a tactic to try to figure out where the abused partner has gone after fleeing the abuser. If law enforcement asks you if you know where the survivor is, and you tell them that she or he is or is not in shelter, you have provided information that may get back to the abuser and tell them what they want to know, where to look for the survivor, at the shelter, or maybe they need to look elsewhere with other friends and family. Perpetrators also use this information to humiliate victims, to harass them, to isolate them, to control them, to threaten or intimidate, and sometimes to assault or kill. If a family member or the prosecutor asks you whether or not a crime victim is attending a specific support group, or is seeing a therapist, or is planning to testify, could that information be disclosed to the defendant's attorney and thus to the defendant? Could the defendant use that information to harass or humiliate or intimidate the victim, especially if they want to coerce the victim out of testifying at trial? Let's talk a little bit about what privacy, confidentiality, and privilege mean. Privacy means I get to decide who knows my information. Confidentiality means you, the service provider, commit to protecting my information from disclosure. And privilege means others cannot compel you to share or disclose my information. This is a wonderfully succinct analysis that's been prepared by Alicia Aiken of the Confidentiality Institute, and I encourage you to go to that site to get additional resources to understand this in more detail. So let's talk a little bit more about privacy, confidentiality, and privilege, and who gets to enact it or exercise it. So for privacy, the victim or survivor exercises their right to privacy by controlling as much as is possible or desired to whom they disclose and how much they disclose. As we talked about this earlier, they need this for safety and in order to be able to make decisions fully empowered. Confidentiality is something that service providers and professionals promise or are ethically bound to by nature of their profession. And they do this in order to create relationships of trust and best serve the victims and survivors with whom they work. Privilege is bestowed by government, either through laws, statutes, or historical development of case law. Privilege are rights to withhold information from any legal proceeding without suffering legal consequences, for example, being held in contempt of court. Governments do this, they create these privileges when there is societal value in protecting this information from disclosure. It's important to understand that while these terms are different, they're often used to refer to the general obligation to keep things private and confidential. These confidentiality obligations and government-created privileges are linked, and they all function to protect the privacy of the victims that you serve. Protecting their right to decide who gets information from them or about them means that they are better able to use our services and to keep themselves safe. There's some resources here that you can turn to for some additional information. This first one on this page, the Confidentiality Policies, Considerations, and Recommendations, a resource manual, was prepared for domestic and sexual violence programs by the Michigan Coalition to End Domestic and Sexual Violence. But many of the concepts in it are something that anyone working with victims and having confidentiality obligations could use and would be helpful. As well, the Confidentiality Institute website has lots of great information, resources, articles, and links to other resources to help you think through these things and perhaps work with your colleagues to develop policies and protocols. And finally, there's a great video that was prepared by the National Domestic Violence Fatality Review Initiative featuring Alicia Aiken, the Executive Director of the Confidentiality Institute, on confidential information and how it interrelates with fatality reviews, but also a very good basic review of what you need to be thinking about. So all these resources could be helpful to you as you begin to work through and make sure that you are keeping victim information confidential when required to do so.
Understanding the confidentiality requirements of VOCA, FPSA, and VAWA. This is Module 2, the federal funding mandates and who's covered. This module is going to cover the federal funding mandates, the differences between community-based and system-based advocates, including what the differences mean with respect to your application to maintain confidentiality. So you should have already heard Module 1, which included why privacy and confidentiality are important to the work that you do. In the future, we're going to examine the concepts of personally identifying information and individual information that's protected from disclosure under VOCA, VAWA, and FPSA. We're then going to cover releases of information, and we're going to finally, in the final module, cover when disclosure is mandated by statute or lawful court order. So in Module 1, we covered why confidentiality and privilege are foundational to helping relationships. It supports individual empowerment, autonomy, dignity, and safety. And this commitment to confidentiality encourages people to reach out for help. So society has recognized the values of these relationships and has put legal structures in place to foster and protect important relationships that involve private communications. The legal protections are covered in relationships such as social worker, family counselor, licensed professional counselor and their clients, psychologists, psychiatrists and their patients, attorney-client privilege, domestic violence and sexual assault counselor privilege, physician-patient privilege, statutory protections like HIPAA, that's the Healthcare Insurance Portability and Accountability Act, professional and ethical standards, and licensing standards. So why is the law built up around these relationships? So I'm an IV drug user seeking care for a doctor. How important is it for her to know that I'm an IV drug user? Will it impact the treatment she provides and the resources she offers me? Absolutely, but only if she knows and I trust the relationship enough to tell her. We as a society have decided that these relationships and the help offered in them are incredibly important, and we want to foster these relationships. So we're not going to focus on this list of rules and standards I just went over. However, you should know that there are other rules, laws, and ethical standards that may apply to you. For example, if you belong to one of these professions. If you're covered by more than one rule, it's important to know that you must follow the most protective of the confidentiality rules that may apply to you. You can learn more about these confidentiality rules from your professional associations that you may belong to. I also encourage you to take a look at a manual published online by the Michigan Coalition to End Domestic and Sexual Violence entitled Confidentiality Policy Considerations and Recommendations. It was designed for domestic violence and sexual assault programs, but it contains a wealth of information about the application of some of these very specific privileges. It and other resources are going to be linked at the end of this presentation. You should definitely check them out. So our focus today is really going to be on the federal rules that cover you in your current position. So these are the rules, regulations that are attached to funding that is administered by the Division of Victim Services. These include Victims of Crime Act funding, VOCA, Violence Against Women Act funding, VAWA, or Family Violence Prevention Services Act funding, FIPSA. As a condition of receiving this federal funding, your organization or agency is required to follow the federal statutes, rules, and regulations governing confidentiality. Luckily for all of us, the federal government has aligned the confidentiality rules across the sources and makes the rules essentially identical across these three different funding sources. So these rules are based on the same ethic of protecting helping relationships as all of the professional privileges we just talked about. They were passed with the understanding that confidentiality is the cornerstone of good victim services. As administrator of these funds, the Division of Victim Services takes these rules incredibly seriously. Eligibility for funding is conditioned on having policies in place to follow these rules. And in the case of a grave enough breach of confidentiality, your organization could be subject to a confidentiality audit and funding could actually be terminated. So the basic rule is pretty easy to understand. We're going to go over it briefly and we're going to dig more in depth into it in future modules. So the basic rule is don't release personally identifying information about a person who has utilized, requested, or been denied services unless 1. The individual is signed a release, 2. A court has ordered that you share the information, or 3. You're mandated by law to share the information. So we're going to review each of these much more in depth in future trainings, but for example, we're going to discuss when personally identifying information actually is and run through a few scenarios to help you understand the shape of what PII is. We're going to discuss what is required to execute a release of information. Here's a hint, it's specific, written, time-limited, and informed. We're going to deal with that much more in Module 3. And then finally, we're going to discuss times when your agency or you may be required to release the information without client consent. And this is when there's a court order or a legal mandate. But as complicated as this issue can get, holding on to the basics is critical. Before you talk about or identify a client or service participant with anyone, you should always ask yourself, 1, do I have a release? 2, has a court ordered me to tell? 3, does the law mandate that I tell? We can use these 3 simple questions as a touchstone. So let's try an example. Jerry is a 19-year-old man. He's a victim of crime who has been receiving services from your organization for about 2 months. You've been working with Jerry, providing housing and employment advocacy. One day, Jerry's grandmother calls you looking for the names of referrals that you've given Jerry because she wants to help him follow up with these referrals. Can you tell her anything? So what's our first question? Do I have a release? And in this case, no, you don't have a release. Our next question, did a court tell me to do this? Did a court tell me to share information with grandma? And the answer here is no. And then our final question, does the law mandate that I tell Jerry's grandma anything? Unless there's some law I don't know about, the answer here is no. So we're going to talk a lot more about this in the next module, but one of the things that you can't do is confirm or deny that someone is receiving services from you. So by providing information, you're essentially confirming that you're providing services to Jerry. Like I said, we're going to dig more into this example in the future, and we will also think about some ways we can respectfully respond to Jerry's grandma while maintaining Jerry's confidentiality. I do want to acknowledge that this is hard. It seems like a simple request, doesn't it? She just wants to be helpful, and you can't tell her anything. This gets to the heart of why these rules are hard and why seemingly simple, they can be very hard in practice. We're surrounded by people who may be trying to help the victim, family members, friends, or even professional colleagues from different systems. Again, we go back to those touchstone questions always. Do I have a release? Has a court ordered me to tell? And does the law mandate that I tell? As I said, we'll come back to these in future modules in more depth. So we're going to switch gears for the last part of our conversation and talk about who within an organization must follow the federal confidentiality rules. So a frequently asked question is whether the confidentiality provision applies to the entire victim service provider or victim service division of an organization, or only the funded activities or funded individual. So you may work in a situation, for example, where you're one of 5 employees in the victim service unit. One of you is funded by VOCA, one's funded by United Way, one's funded by a foundation or other funding source, and one actually may be a volunteer and not funded at all. So who does the confidentiality rule apply to in that situation? So the answer here is the confidentiality provision applies to all the operations of the victim service provider or the victim services division or component, even if the VOCA, VAWA, FIPSA funding is only for a small portion of those operations. And critically, the rule also applies to volunteers who aren't even funded staff persons. This ensures that service provision and confidentiality is not dependent on which employee answers the phone or greets someone at the door. It makes it easier for agencies to create policies and procedures that are consistent with these requirements. So next comes to the question of umbrella organizations. So the confidentiality rules do not apply to employees working outside of the victim services unit or division of an organization. You may work at a large umbrella organization such as a hospital, university, YWCA, community action agency, or community-based human service organization. The federal confidentiality rule applies only to the victim services unit of that organization. For example, if you work at a culturally specific human service organization that provides daycare, victim services, a food bank, and translation services, the confidentiality rule will only apply to the victim services unit. It's important to note that the other units may have their own rules, regulations, or licensing standards that protect privacy. We're going to talk more about these kind of organizations when we talk about release and information sharing within the same organization, but essentially you will not be able to share information with these other units in the absence of a court order, release, or statutory mandate. As I said, we're going to come back to this concept in the future. The same is also true when a tribe is the grant recipient. The confidentiality rule does not apply to all divisions of the tribal government, just the victim services division. Finally, we're going to switch gears one last time to talk about who within an organization must follow the federal confidentiality rule. So who does the rule apply to? In general, the rule applies to employees working in VOCA, VAWA, FIPSA-funded organizations that provide victim services. Essentially individuals such as victim advocates, outreach workers, counselors, therapists, SART coordinators, volunteer coordinators, on-call responders, residential advocates, children's advocates, legal advocates, and volunteers. There is one exception within the rule for law enforcement and prosecution information generated for law enforcement and prosecution purposes. This has been interpreted to mean that the rule does not apply to victim witness assistance. The Department of Justice has expressly indicated in an FAQ that victim witness assistants are not covered because they're not providing victim services. Although the services they provide help victims, they're also assisting with investigation and prosecution. For the vast majority of positions funded by VOCA, VAWA, and FIPSA, the rule will apply to you. You should assume it applies. If you have any questions, please reach out for help. So let's think about it. You're a legal advocate funded by a victim service agency. You regularly accompany victims to court, and 2 days a week you work out of space that is provided for you at the prosecutor's office. You regularly sit in with the prosecutor as he prepares victims for trial. Do you have to follow the confidentiality rule? And the answer here is yes. Just because you work regularly with law enforcement and prosecution does not mean that that exception for law enforcement and prosecution applies to you. The only time the rule doesn't apply is when the individual, such as a victim witness assistant, works directly on behalf of or for law enforcement and prosecution. Again, for the vast majority of positions funded by VAWA, VOCA, and FIPSA, the rule would apply, and you should assume that it applies to you. And if you have any questions, again, just please reach out for some help. So this concludes Module 2. You'll find some resources and links here that we mentioned today. First is the Confidentiality Policy and Considerations Manual from the Michigan Coalition to End Domestic and Sexual Violence. And then the Confidentiality Institute is a website that has lots of great resources about all 3 of these rules. And then finally, there are frequently asked questions. It's published by Office of Violence Against Women on Confidentiality, and I've linked that here too. That's a very helpful document. Thanks for your time, and I look forward to talking with you again.
This is Understanding the Confidentiality Requirements of VOCA, FIPSA, and VAWA. It's Module 3 on Personally Identifying Information and Individual Information. This module will cover understanding what personally identifying information and individual information is, and we'll also explore what constitutes that, some examples of that, and how to protect against inadvertent disclosure of confidential information. Past modules that you've already listened to are Module 1, Confidentiality and Privacy, Module 2, Introduction to the Federal Rules, and then future modules will be on how disclosures can be made with a release and when disclosures are mandated by statute or by lawful court order. Just remember, don't release personally identifying or individual information about a person who has either utilized, requested, or been denied services unless either the individual has signed a release, a court has ordered you to share that information, or you are mandated by law to share the information. What is personally identifying information? Well, the Violence Against Women Act defines it as information for or about an individual, including information that's likely to disclose the location of a victim of domestic violence, dating violence, sexual assault, or stalking, regardless of whether the information is encoded, encrypted, hashed, or otherwise protected. And the similar statutes in VOCA and FIPSA, and especially VOCA, would protect anyone who is a victim of crime that you're providing services to. They don't necessarily have to be a victim of domestic violence, dating violence, sexual assault, or stalking. These examples on this slide are spelled out in the statute. So personally identifying information includes a first and last name, a home or other physical address, contact information including a postal, email, or internet protocol address, or telephone or facsimile number, a social security number, driver's license number, passport number, or a student identification number, and importantly, any other information including date of birth, racial or ethnic background, or religious affiliation that would serve to identify any individual. These examples are not the only kinds or examples of personally identifying information. These are just what is spelled out in statute as what this can include. The Code of Federal Regulations, though, provides additional guidance for understanding personally identifying information. And it says that it is information that can be used to distinguish or trace an individual's identity, either alone or when combined with other personal or identifying information that is linked or linkable to a specific individual. So let's look. Is this personally identified information? A woman with 4 children killed by her husband. So the answer really is, it depends on context. This information on its own, absent any context, meaning we don't know who the speaker is, we don't know where the speaker is, and we don't know for whom the speaker works, is not personally identifiable. Sadly, in our country right now, this could be about way too many women and children. But let's look a little further. So we have the same personally identifying information, and we will provide context for it. A domestic violence advocate in Detroit is terribly distressed about something that happened that day. She goes home and tells her partner that she had previously worked with a woman who was attacked that day, and her 4 children were killed by the woman's husband. So with that information, you could do a Google search, and this is what would come up. You would see and be able to identify a case involving an identified woman with 4 kids who had been killed by her husband. So what we have to understand is that information that we as advocates, counselors, and people providing services to victims of crime, the information that we provide, if it's identified or linked to other information publicly identifiable, could mean that we have disclosed and violated confidentiality with respect to personal information. The Code of Federal Regulations for this information and PII talks about the fact that the definition of personally identifying information is not anchored to any single category or information or technology. It requires case-by-case assessment of the specific risk that an individual can be identified. Non-personally identifying information can become personally identifying information whenever additional information is made publicly available in any source that combined with that information can identify that individual. Let's take another example. Is this personally identifying information? Your local United Way, that is also a funder, asks your organization to provide it with the following information annually: the number of homeless persons served, with a breakdown of the numbers of adult women, adult men, and children, and the age range of the individuals, both children and adults served. So is this personally identifying information? It is not. Providing the age range of the people you served in a year and the number of women and children and men served does not lead to or link to any identifiable information. Another example. You are a victim advocate with a university sexual assault services program. Your university convenes regular collaborative meetings with your program, the campus counseling service, the campus police, and the Title IX officer to review policy and practice to improve university response to sexual assault. In that meeting, you state that you are working with a sophomore student who was sexually assaulted by 3 athletes at a party 2 weeks ago. Is this personally identifying information, and do you need a release in order to disclose? Most likely, yes. Remember that non-personally identifying information can become personally identifying information whenever it can be linked to or added to other sources of information. In this example, while you haven't identified a person by name, you've provided enough information about that person that if it's linked with other information that may be publicly available or known to other students, would identify the person that you're talking about. You don't know, for example, who else the survivor may have told about their experience, and you don't know whether the athletes have told their coaches or teammates about what happened or what they think happened. That information is outside of your area of control, and it could be combined with your information to identify the person with whom you're working. The federal statute also prohibits the disclosure of individual information. The statute doesn't define what that is, but at minimum, of course, it would cover any of the specific data that is talked about in the statute that would identify the person or the location. But more broadly, it includes any information about that person that's been disclosed to you and for which you do not have a release or a statutory court mandate to disclose to others. Here's an example. John Doe is seeing a mental health counselor at your organization. He has told you many things in the course of treatment, including that he was abused as a child and that he is actively using drugs that his probation order forbids him from using. Is this individual information? Yes. So let's continue on. You have a release that allows you to tell John Doe's probation officer that John is receiving mental health treatment from your agency and the number of sessions he has attended with your agency. Can you tell the probation officer about the child abuse and John's current drug use? No. Individual information shall not be disclosed without a release, and your release does not give you permission or authority to release that additional information about John. That's individual information, and it has to be protected. There's also ways that we inadvertently disclose information without intending to and without realizing it. And grantees and subgrantees of these dollars are responsible for taking reasonable efforts to prevent inadvertent releases of personally identifying information or individual information that is collected as described in other sections of the statute. Inadvertent release means it's unintentional, and we're going to take a look at a couple examples of that. You are at a local conference on low-income housing. You have a release to talk to the landlord of a client. You call the landlord as you are walking from one session to the next session and say, "Hi, this is Lori with the Victim Services Project. Dory May signed a release to let me confirm that we are going to be able to cover 2 months' rent for her while she's off work. But she doesn't feel safe in that first floor apartment she's in, since that's how the guy who robbed and beat her was able to get in. She wants to move to a third floor apartment, either in that same building or in the Harbor Village complex that you'll also manage. Is that possible? So in this process, you may think that you're having a private phone conversation, but if there are people around you who can hear your end of this phone conversation, you have both identified a person by name, provided information that could disclose their location, and disclosed individual information about her and her situation, all of which would violate the Violence Against Women Act, Family Violence Prevention Services Act, and VOCA requirements of confidentiality. Here's another example where you may or may not be engaged in inadvertent disclosures, and this one's a little bit more complicated. Police Officer Banksy calls your organization. Her department has received a missing persons report about Jane Doe. Officer Banksy asks you, is Ms. Jane Doe staying in your shelter? Or has your agency provided Jane with services? Because if she's in shelter, or if you're providing services, they're going to stop looking for her as a missing person. You truthfully tell Officer Banksy that you have never heard of Jane Doe and that she is not in your shelter. Is this personally identifying information or individual information? On its face, technically, no. If Jane has never requested, received, or been denied services from your organization, then technically the prohibition against disclosure does not apply. Because remember that the statutes protect that information about a person who has utilized, requested, or been denied services. But let's look a little further and add to this example. 3 days after that conversation with Officer Banksy calls you to let you know that she has a subpoena for a different client, Marilyn Monroe. She asks you if Marilyn is staying in your shelter or if your organization is providing Marilyn with services. Marilyn is staying in your shelter. You tell Officer Banksy that you can neither confirm nor deny this information about Marilyn. Then that's a standard kind of policy or response that we often give in these organizations. But now, what have you inadvertently disclosed and how have you done that? If your policy and practice is to tell others that someone is not a client, that you have never provided them with services, that you don't know who they are, and that's truthful at the time, but then when you have provided them with services, when they are a client, when they are staying in your shelter, you say, I cannot tell you, or I can't confirm or deny. You are inadvertently disclosing when someone is receiving services from your organization. It won't take very many responses for whoever's making that inquiry to realize when you say, I don't know them, then you haven't provided services. But when you say, I can't confirm or deny, that's a different response, and it means you are providing services. So to avoid this kind of inadvertent disclosure, you must have the same response whether or not you have or have not provided services to a particular person. Some other ways to think about preventing inadvertent disclosures are to think about maintaining secure locations for that information. Keep your files, your documents, and your electronic devices in secure locations where they can't be accessed by people who don't have the authority to see them or have that information. Don't leave them out on your desk where members of the public or people in your organization who don't have the right to see them could pass by and oversee them. Don't leave them in your car where they could be stolen or observed by others. Have conversations and do this work when possible in a private location. Have conversations where you know you cannot be overheard by other people. Don't talk about clients in public settings, not on the elevator with another colleague. Make sure that when you're having these conversations, you're doing it privately. Encrypt electronic files, thumb drives, laptops, smartphones whenever you can. And again, don't leave them out in the open when you're at meetings or in court. And finally, it's really important that your organization have a written, thoughtful, and clear policy on confidentiality and train to that policy If you're a staff person, make sure you ask and you find out what that policy is so that you know that you are doing everything you can to protect the confidentiality and privacy of the people with whom you work. So thank you for listening in to this Module 3. And again, we refer you to the resources that you've received that are helpful in elaborating on some of the things that we've talked about. And if you're working with your agency to develop a policy, that would be helpful to you in developing that policy. So, well,
Understanding the confidentiality requirements of VOCA, FIPSA, and VAWA. This is Module 4, Release of Information. This module covers how to assess whether a release of information is necessary and how to ensure your clients are making a fully informed decision. It covers the elements required for release of information in order to comply with the federal VOCA, VAWA, FIPSA confidentiality requirements, rules, and statutes. And finally, we will cover some of the nuances contained within those elements. So prior modules included confidentiality and privacy, introduction to the federal rule, what information is covered by the federal rule, and what personally identifying information is. Future modules will cover when disclosure is mandated by statute or a lawful court order. So you'll remember the basic structure of the federal rule. Don't release any personally identifying information about a person who has utilized, requested, or been denied services unless 1. The individual has signed a release, 2. A court has ordered you to share information, or 3. You're mandated by law to share information. Today we're going to talk about the first of the exceptions, when an individual has signed a release. As we start this conversation about release, it's important to remember the basic philosophical underpinnings. Victims of crime own their own experiences and the information about their experiences. A few guiding principles flow from this understanding. First, victims and survivors should have access to the written information we keep about them. Second, victims and survivors should decide who else has access to that information. Your agency's policies and practices, and indeed your personal practices around executing a release of information, lets clients know that you and your agency take these principles seriously. So when is a release required? You need a release of information from a client to share any individually personally identifying information about that client with anyone outside of the victim services unit of your agency or organization. This includes even confirming that a particular person is receiving services. You will remember this picture from Module 2 when we talked about umbrella organizations and who must follow the federal confidentiality rule. Here's the other half of that story. If you work in an umbrella institution such as a hospital, university, community action program, or YWCA, you will need a release to share information with individuals outside of the victim services unit. For example, if your organization includes a victim services unit and a food bank, you would need a release of information from your client in order to share information with the food bank, even though you're part of the same larger umbrella institution. The Department of Justice has actually released a frequently asked questions that addresses some of the issues for umbrella organizations, and I encourage you to take a look at that for more information. They're going to be linked at the end of this presentation. So the most typical circumstances when you'd be having to complete a release of information are circumstances where the client's coming to you and actually asking for you to share information with others or to work with other professionals or service providers on their behalf. Typical circumstances when a release of information may be used include a client wants you to talk to law enforcement or prosecutor's office to find out information on the criminal case. A client or another organization wants you to talk with a service organization or government benefits office to help service participants gain access to benefits or to coordinate services. A client may want you to talk with a teacher or school administrator on a school safety plan. And the client may want you to write a letter to verify their need for emergency shelter to gain access to additional housing support. Most of these circumstances are times when you're going to actually have a conversation with another professional or write a letter summarizing services provided to the client. It's extremely rare that you would ever share the entirety or even a portion of the client's counseling or advocacy file. So the basic rule again, When do you need a release of information? You need a release from a client to share any individual, personally identifying information about that client with anyone outside of the victim services unit of your organization. So let's try an example. Officer Banks from your local police department has brought Mariana, a 22-year-old female, to your victim service organization for services. You run into Officer Banks at a multidisciplinary team meeting a week later, and she asks you how Mariana is doing, and she wants your help to get in touch with Mariana. Do you need a release to talk to Officer Banks about Mariana? So take a few minutes here and commit to an answer either in your head or on paper, or a few seconds. So the answer here is yes. Even if Officer Banks knows that Mariana was at your victim service agency, you cannot share any information about Mariana without a release, including the fact that she's receiving services from your organization. The fact that she's receiving services and what you may know about her individual circumstances fall into the category of individual information that we talked about last week. We can go back to our framework at any time this issue arises. Do I have a release? Did a court order me to tell? And does the law mandate that I talk to Officer Banks? So in relations to Mariana's circumstances, the Department of Justice has a recommended response to help us through this kind of scenario. The recommended response has a few steps. First, verify the identity of the requester. Verify that the person reaching out to the program is in fact who they say they are. In Mariana's case, we don't need to verify because Officer Banks is in front of us and we know her. But if the request came through on the phone, you should have a process in place to verify the identity of the caller. Next, explain that as a matter of policy, your agency or program cannot confirm or deny whether Mariana is receiving services. Next, listen, and this is probably the most important step. Indicate a willingness to discuss what Officer Banks needs without confirming whether Mariana is actually receiving services. Officer Banks should be able to explain her need to get in touch with Mariana. Finally, if the program is serving Mariana, you should tell Mariana that Officer Banks is looking for her and why. As a matter of policy, your organization should have a standard response to this kind of inquiry. Part of that standard response could be sharing with Officer Banks that you're willing to get a message to Mariana if you have the opportunity. However, this response would need to be consistent across the agency every time you respond to inquiries about specific individuals, regardless of whether that individual is actually receiving services from you. Because think about it. If you only offer to give a message if an individual is actually engaged in services, you're essentially confirming that that individual is receiving services. Take a look at your agency's confidentiality policy and see how this issue is handled. This scenario is an example that can apply to any number of helping professionals, mental health professionals, or government benefits professionals that may reach out to your organization about individuals you're providing services to. For example, you could get a call from a client's DHHS worker who may be trying to coordinate services, or from a housing program that may be attempting to confirm a client's housing situation. So the key here is to have a standard and consistent response when others reach out to you looking for information about a client. So now we're going to get to the meat of the federal rule. There are 4 elements required for a release of information to comply with the federal VOCA, VAWA, FIPSA confidentiality rules and statutes. The release of information must be informed, it must be written, it must be specific, and it must be reasonably time limited. We're going to dig a little deeper into each one of these elements. But first, a release of information isn't a simple piece of paper. You should think about it as a process and a conversation that you have with a client. So, don't assume a release is the answer. Before executing a release, don't assume that the release to share information is the solution. You and the client should discuss other ways to meet their goals without you having to reveal information about their circumstances or the fact that they're receiving services from your agency. Can the client share the information? Consider whether the client can simply share the information themselves. This could happen under circumstances where you and the client make a phone call together. In this circumstance, the client is able to do most of the talking and decide in real time which pieces of information they want to share. You can ask questions about the process, or you can help the client understand the responses given, but it takes you out of the position of sharing sensitive information about the client's circumstances. This type of approach is consistent with the empowering and strength-based advocacy supported by the Division of Victim Services. Although sometimes it's not practical, particularly if the person you are trying to reach is difficult to track down and you're dealing with a short timeline. And other alternative ways to share. Sometimes the information that a client wants to communicate can be found from some other sources or methods. For example, a client may need a verification that they've received services. This could be accomplished by you writing a letter to that client, verifying the dates of the service, and then the client can share the information with others as they choose. As we review each of these elements, I will be referencing a model release form that was created to comply with the federal rule. This model form was created in collaboration between the Confidentiality Institute and the National Network to End Domestic Violence. Because the form was designed to comply with the federal rule and the elements of the federal rule, it complies with the requirements of VOCA, VAWA, and FIPSA and can be used as a model release for any kind of victimization. You'll see a link at the bottom of the page, the bottom right hand of your presentation, to go on and find that form. So, even though we will reference this form, you should be familiar with your own agency standard release. It should include all of the elements that we're going to discuss today. So now we're going to dig a little deeper into each element. First, in order to comply with the federal requirements, a release of information must be informed. Survivors must know what they're agreeing to in the release and what kind of the risks and the benefits of signing the release are. Clients should know they have a right to confidentiality and that your organization is required to keep their information confidential unless the organization is required by law or court order to release. Next, you should inform clients that release is always voluntary. Clients cannot be required to sign a release of information in order to receive services. Next, you should review the pros and cons of releasing information and discuss some of the alternatives. Some of the pros and cons that should be considered include the confidentiality policy of the recipient organization and the likelihood that the release will help the client meet their goals. Next, the clients should know exactly what information is going to be shared, who's going to get the information, and when the information sharing will stop, essentially the expiration date of the release. Finally, the client should know that they have the right to change their mind and revoke or end the release at any time after they sign it, although you'll not be able to get information back if it's already been shared. So going back to the model form, we can see some of these elements in action. As I said, you should review and be familiar with the form used by your own organization and understand how to talk about these elements with your clients. You can see that the model form has basic information section to review with the clients. It in very plain language tells clients you never have to agree to share information and we will still help and provide services to you. It indicates that a conversation about pros and cons has taken place with the clients and kind of prompts you to have that conversation. And it tells clients that they can change their mind at any time. So moving on down the form, it continues to review the pros and cons. Here it informs clients about the impact of sharing their information. It informs clients that others will know they have worked with the victim service provider and others might try to get more information from the victim service provider. And that the recipient of the information may share it without asking the client's permission first. It requires a brief documentation about why sharing information is important to meet the client's goals. I really like that it includes this section because this ensures that your organization and you as an individual have had a conversation with your client to make sure you have a full understanding of what their goals are and you're thinking through the process of, is this release actually going to help us meet those goals? Next, it outlines with a great deal of specificity what information will be shared and how it will be shared. Finally, it has a section that clearly spells out when the release will end, indicating that the victim service organization will stop sharing my information on a specified date. Moving on to the next element. In order to comply with the federal requirement, a release of information must be written and signed by the client. There are a few frequently asked questions in relation to this element. For example, what about a legally incapacitated person? The release for a legally incapacitated person must be signed by the person's legally appointed guardian. Consent may not be given by the abuser of a legally incapacitated person. If a person is permitted by law to receive services without a guardian's consent, then that person may consent to release the information without further consent from the guardian. Next, what about a child? In the case of an unemancipated minor, both the minor or the guardian and the parent or guardian must sign the release. Consent may not be given by an abuser of the minor or by the abuser of the other parent of the minor. If the minor is a young child that is incapable of knowingly consenting, the parent or guardian may consent on the minor's behalf. In such cases, though, you should attempt to notify the child in an age-appropriate manner. So what about a teen? There are also some circumstances when a minor who is a teen is permitted by law to receive services without a parent or guardian's consent. In such circumstances, the minor may also then consent to the release of information without additional consent from the parent or guardian. Finally, a frequently asked question is, what can we do about an oral or telephone release? The federal rule does not allow for oral releases or for telephone releases. A written release of information is required. One option for this situation would be for when the victim to remain on the call while the third party is contacted so that the victim can provide his or her own information about what's needed. Another option would be to consider having the victim email or fax a written release, provided that you can verify the client's identity. Next, the release of information must be specific. It should be as specific as possible about what information will be shared. For example, if you are sharing information with a housing agency to provide documentation of need, the release should not include details of the assault, the substance abuse history disclosed by the client. Next, it should list the persons with whom the information will be shared. If you don't know the person, at least include a general title, for example, DHHS caseworker. Finally, it should list how the information will be shared, for example, by phone, fax, or in person. Again, you can see that the information is covered effectively and in plain language on the model form. Become familiar with your own agency's form and kind of how these elements are covered there. Finally, the last element is that it needs to be reasonably time limited. Whether a time is reasonable should be determined by the purposes of the release and the circumstances of the survivor's situation. The length of the release is effective should be the minimum length of time necessary under the circumstances and should be tied to the services the survivor is requesting. It should be as short as necessary to meet the client's purpose. For example, a release could be a few minutes, a few hours, or for a few days. This helps ensure that services are guided by the survivor and take into account that situations may change radically from day to day. In general, there's no reason a waiver should ever be more than for 15 or 30 days, since the release can be reaffirmed or extended if the survivor confirms that the release is still valid and authorizes the new expiration date. So let's try an example. I filled out here a mock release form, and this is for Emily, and she's a client receiving services from your organization in April of 2019. She's new to Michigan and has been diagnosed with bipolar disorder. So why don't you take a look at the release and read over the parts that I filled in are highlighted in yellow. See if you can identify any areas of concern with how I've completed it. I'm going to give you about 20 seconds. Great. So before we jump into the release, we should ask if this is a call that you and Emily could make together. Do you really need a release of information? So assuming you do, because you can't connect with that person you need to while Emily is with you, let's review this release. So I see 3 things I would clean up. Before we go into what we clean up, I think the section on why sharing this information helps me is nicely completed and concise. Emily wants help accessing mental health services. The first area of concern that I see is the fairly open-ended statement containing the information to be shared. What do you really need to share to get Emily help and to get Emily an appointment? Maybe it is just the fact that she's working with your organization, or that she's experienced multiple traumas, and possibly that she's been diagnosed with bipolar disorder. The goal here is really information hunting on your client's behalf. So you might not need actually to share a lot of information in order to help her gain these services. The next area of concern I see is that there's no person identified that the information can be released to. If she has someone that she's worked with in the past, put that person's name down. Or perhaps you could identify the title of an individual, such as CMH intake worker. That's much more narrow than allowing the release of information to be anyone at Community Mental Health. Finally, I have concerns about the date of the release. It allows for an entire year. Realistically, you need the release to cover the amount of time it's going to take you to make a phone call and perhaps wait for a call back. In this type of circumstances, 15 to 30 days seems appropriate. So let's review our decision-making tree. Before you share personally identifying information or confirm services or denial, the 3 areas to go through. Do I have a release? Did a court order tell me? Or does the law mandate that I tell? We can add this piece to the decision tree. If you do have a release and a release is necessary, is it informed? Was it written and signed? Is it specific? Is it reasonably time limited? And are all the alternative ways to share the information that don't actually require a release? For example, can the client share it on our own behalf? So many more questions. We've gone over a lot today, and I realize this is a complicated and nuanced issue that may raise additional questions. For example, what about releases originating from other organizations? What if a client wants a copy of his or her entire file? What information can we discuss with MOU partners and multidisciplinary team partners without a release? If there's a cooperative agreement form signed by all professionals involved, stating that any information shared during a meeting will not be shared outside of the meeting. So what happens in that kind of circumstance? What if a client is deceased and information is needed for a fatality review? What about sharing files during site monitoring? So all of these are great questions, and luckily they have been answered. We're not going to go through them here, but I'm going to let you know where you can go in case these are any questions that are in your mind. So many of the questions and examples we covered today are reviewed in greater depth in these sources. Please take some time to do some additional reading and take advantage of some of the FAQs, resources, and toolkits. First, the frequently asked questions on the VAWA confidentiality provision. You may have noticed that several of the slides today specifically cited questions from this document. Next are the frequently asked questions on confidentiality and release. Is also an excellent resource from the National Network to End Domestic Violence. And finally, there's a really good confidentiality toolkit developed by NNEDV Safety Net and the Confidentiality Institute. This is an excellent resource that also contains sample forms, documents, and other additional information about keeping information confidential in the digital age. So thanks for listening today, and thanks for the work that you do on behalf of victims of crime.
So welcome to the last or fifth module for our Understanding the Confidentiality Requirements of VOCA, FIPSA, and VAWA. This is Module 5. We're going to be covering mandated disclosures. This module will cover disclosures, common ones that are mandated by statute under Michigan law, what happens when disclosures are mandated by a court order, and what you need to do after you have made a mandatory disclosure. The past modules covered confidentiality and privacy. We introduced you to the federal rules and laws on confidentiality and privacy. We talked about personally identifying information and individual information, and we discussed releases of information. This module is going to be talking about the last exception to confidentiality. We want to caution you that it is an overview and not an exhaustive list of all the possible mandated disclosures that could occur under Michigan law. The mandate to disclose is very fact dependent and content dependent. When you are working on a particular case and you believe that you may be required to disclose otherwise confidential information, we urge you to consult with your supervisor and or your organization's attorney to explore the issue and make a decision. Let's review what we've talked about already. You cannot release personally identifying or individual information about a person who has utilized, requested, or been denied services. The only exceptions are, number 1, the individual has signed a release. Number 2, a court has ordered you to share that information. Or number 3, you are mandated by statute to share that information. We've already discussed releases in Module 4. In this module, we will review these last 2 exceptions. What does federal VOCA, VAWA, and FIPSA say about these exceptions? If you are disclosing information under one of these, you must make reasonable attempts to provide notice to the victims who are going to be affected by that disclosure, and 2, take steps that are necessary to protect the privacy and safety of persons affected by the disclosure. We'll talk a little bit about that more at the end of this module. So let's talk about two of the most common instances of when disclosure might be mandated by statute. That's when there's issues of child abuse and neglect, or when there's vulnerable adult abuse or neglect. So with respect to child abuse and neglect reporting, it's important to understand who is mandated to report. The list here that you see is an incomplete list, and so if you want to see who all the kinds of healthcare providers or social workers are who need to report, you'd want to go ahead and look at the statute. But these are examples of mandated reporters under the Child Abuse and Neglect statute. Healthcare providers, psychologists, counselors, therapists, social workers, school administrators, counselors and teachers, law enforcement, clergy, regulated child care providers, and then there's a list of certain Department of Health and Human Services employees who are required to report. And they're required to report to the Department of Health and Human Services. There is, and has been now for several years, a centralized hotline or phone number to which you can call in that report. Who else is mandated to report child abuse and neglect? Michigan law says that any employee of an organization or entity that as a result of federal funding statutes, regulations, or contracts would be prohibited from reporting in the absence of a state mandate or court order, these employees are mandated reporters. This is important for us because you are employees of an organization that receives VOCA, VAWA, or FIPSA. And as a result of that, you are prohibited from reporting in the absence of a state mandate or court order. Because of that, you fall within this other section of mandated reporters. And since you would otherwise be prohibited if there wasn't a mandate, you are now mandated as an employee of that organization to report child abuse or neglect. What triggers your duty to report child abuse and neglect? First, you have to have reasonable cause to suspect that child abuse or neglect has or is occurring. Child abuse is defined in the statute as harm or threatened harm to a child's health or welfare caused by non-accidental physical or mental injury, sexual abuse, or maltreatment, and that harm has been done by a parent, a legal guardian, or any other person responsible for the child's health or welfare, or by a teacher, a teacher's aide, or a member of the clergy. So it's important to understand that the duty to report is based in part on the status of the person who has caused the harm or neglected the child. Not all abuse of a child is reportable child abuse under the statute. For example, if the next door neighbor assaults the 14-year-old boy living in your client's house, that may be a crime and it is clearly abusive activity, but it is not reportable child abuse that you would be mandated to report. The abuse or assault was not committed by a person about which you need to report or must report. It was not committed by a parent, legal guardian, or other person responsible for the child's health or welfare, or by a teacher, a teacher's aide, or a member of the clergy. And also note that Michigan statute says that pregnancy of a child less than 12 or the presence of a sexually transmitted disease in a child who's over 1 month but less than 12 is reasonable cause to suspect child abuse or neglect. And that's regardless of whether you have reason to suspect or believe that one of these persons noted in the act did this. That in and of itself is enough, regardless of who may in fact have impregnated that child or how they may have contracted the sexually transmitted disease. With respect to child neglect, if you have reasonable cause to suspect child neglect and you are a mandated reporter, you would be mandated to report that. That neglect is harm or threatened harm to a child's health or welfare by a parent, legal guardian, or any other person responsible for their health or welfare. Note that this child neglect provision does not encompass clergy, teacher's aide. Those are not people responsible under statute for the child's health or welfare. And negligent treatment, including failure to provide adequate food, clothing, shelter, or medical care, could be child neglect, or placing a child at an unreasonable risk of harm by failing to intervene or eliminate that risk when the parent, legal guardian, or other person responsible for that child has or should have knowledge of the risk and is able to act. What must be reported if child abuse or neglect is suspected? What you must report are the name of the child and a description of the abuse or neglect. If possible, the names and addresses of the child's parents or the child's guardian or the persons with whom the child resides and the child's age, and any other information you know that might establish the cause of the abuse or neglect and the manner in which the abuse or neglect occurred. So these elements or factors are important because this is what you are mandated to disclose. Any other information that you may have, you would not be mandated to disclose, and therefore disclosure of that information would mean you have violated the confidentiality provisions of VAWA, VOCA, and FIPSA. Let's look at a child abuse scenario. You are providing substance abuse counseling to a survivor of domestic violence. During a meeting with her, she discloses to you that when the father of her 5-year-old son picked her son up for parenting time this past weekend, the son didn't want to go. The father dragged her son by the arm across the sidewalk for about 10 yards, causing some deep, wide, and bleeding abrasions on her son's knees and one hip. Assume you are a mandated reporter and that you believe this is child abuse. You make a report. Must you tell CPS about mom's substance abuse history and counseling sessions with you? Or can you tell CPS about that? No. The exceptions for mandated disclosure are limited to that which you are mandated to disclose. In this instance, based on the facts given in the scenario, your client's counseling and substance abuse history is not causally related to the abuse or the manner in which it was caused. Another common mandated duty to report created by statute is vulnerable adult abuse reporting. Who is mandated to report under this? It's any person who is employed or is an employee of an agency that is licensed, registered, or certified to provide healthcare, educational, social welfare, mental health, or other human services. It's a law enforcement officer, and it also includes an employee of the Office of County Medical Examiner. Again, the question of whether or not you would be a mandated reporter under the Vulnerable Adult Reporting Statute is a question of fact and of law, and you would need to consult your supervisor and possibly your agency attorney to get accurate information that allows you to know whether or not you need to report something. What triggers reporting of vulnerable adult abuse? It's abuse, neglect, or exploitation of a vulnerable adult. Abuse is harm or threatened harm to the health or welfare caused by another person, and it can include, but is not limited to, non-accidental physical or mental injury, sexual abuse, or maltreatment. Now, it's important to know that we're speaking of vulnerable adults here, and that's defined as a person who is unable to protect him or herself due to a mental or physical impairment or advanced age. What must be reported? The name of the adult and a description of the abuse, neglect, or exploitation. If possible, the adult's age and the names of and addresses of the adult's guardian or next of kin. Other available information that may establish the cause of the abuse, neglect, or exploitation and the manner in which that occurred. So it's very similar again to what you need to report and are required to report under the Child Abuse and Neglect Reporting Statute. And again, you also report this information to the Department of Health and Human Services. Now that we've talked about the common statutory mandates for disclosure, we want to just quickly talk about what it means to be mandated by court order and some common instances of that. That would include a subpoena, a search warrant, or an arrest warrant, and something that we call the common law duty to warn. Court orders that may mandate disclosure could include a subpoena to testify or produce documents. Now, oftentimes people think of a subpoena as a document that is signed by a judge or a magistrate, by a court official, and oftentimes that's the case. But subpoenas under Michigan court rule can also be signed by an attorney, and subpoenas signed by an attorney have the effect of a court order. So just because it's signed by the attorney does not necessarily mean that you will not have to treat it as a court order. Other court orders that may require disclosure could include a search warrant for the premises. This is something that happens for staff that work within shelters where residents are living. That could be a domestic violence shelter, sexual assault shelter, and or a homeless shelter, or an arrest or a bench warrant for a victim that you are serving, and they may come to your facility to see if that person is there. Do you respond? Do you comply? Well, whether or not you do is, again, very fact dependent. So you will need to immediately consult your supervisor and your agency attorney. Understand that failure to comply with a valid court order, a valid subpoena, a valid search warrant, or a valid arrest or bench warrant could impose some significant liability or risk. So you need to understand whether you are actually required to comply, and to comply to the extent that you are mandated to do so by that particular court order. There's also something called the common law duty to warn. Some professionals may have a duty to warn when someone with whom they are working presents a threat of harm to a third person, or perhaps a threat of harm to the person themselves that they're working with. Whether or not you would have a duty to warn depends on your profession and your relationship to the person who presents the threat. If case law creates a duty for you to warn about serious physical injury, then federal regulations may consider that to be a court mandate to disclose. If you are working with someone who discloses to you that they are considering hurting or harming themselves or another person, you would need to consult with your supervisor immediately and your agency attorney to determine if you have a duty to warn, and if so, to whom you convey that information, and that you convey only that information that complies with that duty. Understand that if you do not have a duty to warn and you disclose information, you could possibly then be in violation of the federal prohibitions on disclosing confidential information, personally identifying information, and individual information. So you've done a mandatory report. Now what? Let's return to the fact that once you make a mandatory report that's required by either Michigan statute or by Michigan law, by a court order, you must make reasonable efforts to notify that victim. And you must take steps necessary to protect the privacy and protect the safety of that victim and anyone who would be affected by that disclosure. Let's think back to that earlier scenario with the survivor whose son was dragged by the father, and that you made a child abuse report. Because that mother with whom you are working is a survivor of domestic violence, and the father is the person who's perpetrating the coercive control and abuse on her. That person, the father, may decide to retaliate or seek to retaliate because they suspect or believe that the mother is the one that's the source of that information that's led to a child abuse investigation against him. And so there are safety risks to that survivor. As well, for any other victim with whom you're working, there's also just the risk that that information would be embarrassing, humiliating, could affect their job status. So these are the kinds of things that the federal law says. We realize that you may have to report some of this, but if you do have to report it, you also have a corresponding obligation to seek to protect that person, to let them know immediately that you have had to notify someone about this, and to do whatever you can to ensure their privacy and their safety. So we have an additional resource at the end of this particular module, and that's the first one you're going to see on this page. That's a resource on the State of Michigan Department of Health and Human Services website that has lots of different resources available to you there to understand the duty to report, whether or not you are a mandated reporter, and a video on how to do an online report. So there's resources there that will help you understand that a little bit further. I want to thank you for listening to this and all of the other modules, and we hope that this gives you a little better understanding of the obligations that you have both to protect privacy and confidentiality and to work with victims when you've had to disclose information under a statutory or court mandate.
This concludes our confidentiality training. If you have any questions, please don't hesitate to reach out. Thank you for your participation and attendance.